Thanks for everyone for joining us. I know we have folks joining from around the country, and we have staff and faculty. We have current students that are undergrads, some grad students other places, even our alumni who are in doctoral programs. So we certainly have quite an array of audience. So we appreciate you joining us. We hope you're all staying safe and healthy. This is obviously an odd and unprecedented time for all of us. And we hope you and your families are doing well in this challenging time. We're here at Roger Williams, we are doing an awful lot of testing, and we have kind of hybrid people are in and out of classes, and we're doing the best we can. Thankfully, knock on wood, we're doing okay. So we hope you're doing well as well. But thank you for joining us. My name is Marcus Hanscom. I'm the Director of Graduate Admission here at Roger. I know I've talked to some of you over time at fairs and different events that we've done, and certainly some of the faculty and staff from other schools. We appreciate your continued partnership with us and kind of educating about the fields of forensic and legal psychology, because what we've learned, and I've seen this firsthand at a lot of colleges around the country the last several years when we at least were allowed to travel, we talked to a lot of students who forensic and legal psychology really sounded jazzy and fun and something they're interested in doing, and oftentimes it was led to by something they saw on television. And we've spent a lot of time talking about what is and isn't true around that. But we know there's a lot of interest, and certainly the job market for forensic and legal psychologists is huge. There's a huge job demand right now. And so there's a lot of interest in that. And we hope that this is our kind of first lecture series that we're doing on forensic and legal psychology, and hope that's an opportunity to really educate you and your students and your colleagues about the fields and what ultimately you'd be getting into. And first up tonight is our focus on legal psychology, because that's really only one half of the coin. And often forensic psychology is kind of the buzzword that you hear. But there's a lot of students that do some really great research and ultimately work as trial consultants and other things in legal psychology as well. So we have two of kind of the foremost people in legal psychology, certainly that I know, but are very well regarded across the industry. And we're happy to share them with you here. We're fortunate to have them on our faculty here at Roger Williams, but they are very well renowned across the field, and hope that you'll have opportunities to hear a little bit more about that as we go along. Just as a brief logistics point, if you have any questions, please use the questions and answers box that you'll see on your screen. And I'll kind of moderate that as we go along. And so what we'll do is each of our presenters will have a block of time to talk about their topic, and then we'll have some time for you to ask questions specifically to them. And Dr. Platania will be up first, and she's got to head out at 5:30 Eastern time. So we'll have her present and do Q&A then, and then we'll go over to Dr. Berman's work. So without any further ado, I just want to introduce briefly Dr. Platania, who I've had the good fortune of working with directly for the last several years. And she was our program director for the forensic and legal program, now is our chair of the psychology department. And she and Dr. Berman actually both earned their PhDs at Florida International University. So some of you may be from FIU. I know I've got a couple of events with FIU later this week, so we're excited for that. Dr. Platania is a professor of psychology here, and over the last 25 years, her research has focused on legal and extra-legal factors that jurors consider during the sentencing phase of capital trials. And I got to see her present firsthand at EPA a few years ago. Some of you may have been at that session where we had standing room only, and people were sitting on the floor everywhere because there was such an interest in capital punishment in those trials. Currently, her research team of undergrad and grad students are empirically examining how affect may help explain how jurors think about improper prosecutor argument. And I know that's something she'll be talking with you about tonight. Her published work is most often the result of collaborative efforts of colleagues and current and former graduate students, and it's nothing short of amazing, some of the things I've seen them do nationally and also now in PhD programs. Dr. P also brings her professional experience as a trial consultant into her research and teaching. And what she probably won't tell you openly, but she was involved with trial consulting around the Timothy McVeigh trial in the Oklahoma City bombing. So a major, major case in the 90s. And she's got some great trial consulting experience. I know she's taken some students on that work as well. So I'm going to pass it over to Dr. Platania. And again, if you have any questions, feel free to ask them in the box. But thanks again for joining us.
Thank you, Marcus. Let's see if I can do this. I thought it might be a good idea to spend a little bit of time telling you something about my research, but also a little bit of time telling you about some of the things students have done in my lab in the graduate program. That would be interesting as well as you're thinking about what your options are, if you're interested in research, if you want to enroll in Roger Williams' master's in legal and forensic psychology. So let me start by saying this. A simple Google search will give you this definition, and it's pretty on target, that a legal psychologist works with empirical psychological research on matters of law and individuals who come in contact with the law. Professionals in the area of legal psychology study jury decision-making, eyewitness memory, and legal investigations. So this is just a broad brush stroke of what exactly do legal psychologists do. And if you were to peel apart the layers and attempt to discern what a forensic psychologist does, then you would see that those matters that are more clinically related. So if we're speaking about defendants, for example, it isn't from the perspective of how would jurors think about a defendant. It's more risk assessment, likelihood of committing a crime in the future, matters of civil commitment, expert testimony, and those kinds of matters. So those are the differences. And we have faculty researching both active research programs in legal and forensic psychology. And certainly I'm sure you're looking at them now to see if your own interests match some of what our clinical and legal psychologists are doing at Roger Williams. Now, my research, as Marcus said, and this is many, many years, over the last 25 years, my research has examined extra legal factors that jurors consider specifically during the sentencing phase of capital trials. Now, the focus has been on each of these two areas, and you see in parentheses, it says this research is ongoing. It's ongoing because both of those research streams are pretty exciting. And my students, former and present students, will tell you that when you conduct research and studies bear interesting findings, that always brings you to the next level. What's up next? And so we're always finding something interesting and new in each of these areas. Just to give you a little bit of a background, there are many different types of prosecutorial misconduct. The particular type that is the focus of my research is what happens during closing argument. That is specifically related to the sentencing phase of capital trial. And this means that during closing arguments, prosecutors historically have made statements that border on illegal. And at the very worst, during the context of the sentencing phase, may not necessarily present the defendant in the best light. So what I have done over the years is look at not only differences in verdict, if participants are exposed to misconduct or not, but perceptions about these arguments. Are there themes that develop in prosecutors' arguments? And now what we're doing is looking at a theoretical perspective of improper prosecutor argument. So now we've moved to, well, why does this happen? And Dr. Berman can tell you as well, we are applied psychologists. And I don't believe there are any more applied areas than legal and forensic psychology. And with that in mind, to attempt to connect theory to applied issues is not easy. So as I tell my research methods class, and I know that a lot of you are there right now, it's important to ask that question first and then think about how that theory can be applied to your specific research question. So right now we are looking at positioning theory, and we are examining the extent to which individuals actually position themselves, take a stance on an argument And if you look at an individual's position as an individual difference variable, so what is within me and the factors that lead to how I feel about improper statements will be somewhat different than another person. So with this underlying theme of how individuals position themselves, now we're in a good position to answer that theoretical question, why is this happening? So this research, again, is ongoing and published, and the results converge on the notion that, yes, you find differences in juror verdicts. Yes, it's overwhelming. Individuals who hear statements, regardless of the themes of the statements, are more likely to find the defendant for the death penalty. Second area, and Dr. Berman has published with me on a couple of these studies, is judges' instructions. And again, this is specific to the sentencing phase of capital trials. And without getting into a whole lot of specifics, because it's already 5:15, I say, that the area of judges' instructions is interesting because it allows students, when they participate in this type of research project, to look at the array of judges' instructions to select out those that would be more interesting if you have cases where the defendant may have been a victim of abuse, where you have cases where you're looking at victim impact testimony. So another reason why this particular research is ongoing is because it's very interesting to students, and it is more about what is happening beyond do they comprehend instructions, and more how do these instructions now play out in verdict. Interestingly, my research with graduate students since the inception of the program, which is 2006, has resulted in 11 publications shared with graduate students and over 40 conference presentations. And that's both papers and posters, and it includes graduate students from 2006 to the present. Some of the areas, in addition to those two research streams that you just saw, that have been in my lab, and currently 2 of them are under review. One is last year's graduate student's thesis project, is information processing in civil cases. So that opens the door to another real interesting area. And the reason my interest extends to civil is my work as a trial consultant, but that's for another time. Procedural justice issues, particularly with respect to law enforcement, and individual difference characteristics. Now I'm going to get to the end. And this is what's going on right now. Well, in my lab, I have one grad thesis, and my graduate student on her thesis project is applying theory to understanding intimate partner violence, which has not been done yet in the literature. So what we're doing is looking at different theoretical explanations for betrayal trauma, learned helplessness, and attempting to fit them into intimate partner violence scenarios and looking at, in an array of questions, which theory might provide the best explanation for certain sets of circumstances. My directed research, which would be a requirement in your first year, is looking at expert testimony of a traumatic brain injury as a function of cross-examination, empathy, and procedural knowledge. Procedural knowledge, again, is another individual difference variable, but theoretical. We're looking at the effect of different ways that individuals actually come to know things in the world, and whether there's a connection between how an expert portrays a traumatic brain injury, how they respond to cross-examination of testimony, and it is a direct relationship to empathy. So we're looking at empathy as well. And my undergrads are looking at the body cam as the new eyewitness. And it's a new area. And if you're interested, some of the research that's out there is very interesting, but we're interested in looking at whether there are any significant differences in a body cam, for example, versus recording from your telephone versus a witness's testimony of what they believe to happen. And that is what I have with respect to research interests. And here's my information. If you have any questions that you don't get a chance to ask today or that you think of, you certainly can email me. And I'd be happy to talk to any of you about your own research interests and whether we think they could work out nicely in terms of projects if you decide to apply to Roger Williams. Questions? Are there? Oh, that was the early one.
Yeah, there is a question here, Judith. Do publications or studies include a lot of field research as well as meta-analysis, theory study, and other things?
I'm not sure what you mean by field research. Our research does not include meta-analyses. I'm not aware of anyone at Roger Williams that is currently conducting meta-analyses. Our research basically involves samples of jury-eligible individuals that are most often captured through the crowdsourcing site of Amazon Mechanical Turk. If we have extra grant money, we're able to branch out to those kinds of sites that are offering samples, but they require a bit more funding, like studyresponse.com, which is an excellent site, but it is significantly more expensive. To work with actual jurors, we don't do that. That really is not allowed in too many jurisdictions. And that's pretty much what the research is right now. So we look more at individual juror decision-making.
And his clarification there was like asking participants versus utilizing previous research to apply to new issues.
Oh, no, previous research is a part of applying new issues, but the research is always with fresh samples of individuals.
And maybe something that's kind of related, Dr. P. I know you've done a lot of trial consulting, and we have a few minutes. I think it would be helpful for our audience to understand what exactly is trial consulting and what does that involve?
When attorneys have cases that involve complex matters that they need assistance with respect to how psychology can help them understand how individuals, ultimately jurors, will understand legal matters. And this is not just criminal, it's also civil. And this doesn't necessarily have to be matters that are headed to trial. They can be matters that can be resolved before trial. They'll hire trial consultants, and they will hire a trial consultant for their knowledge about psychology. They're not interested in how much you know about the law. My experience as a trial consultant has been working with attorneys to develop issues and themes for juror understanding, mock trials, focus groups to test out those issues and themes, and to increase an attorney's level of awareness of issues that are important for their interest, whether it's the plaintiff or the defendant. And that's important because in the years that I've worked with attorneys, I find that they can have a great handle on legal matters. But when it comes to understanding how to present those legal matters, the information that's in their closing statement arguments, in their opening statements, doesn't find itself very well for jurors. So our job is to help them understand how to think like a juror. What can we say to attorneys that will help them put their best case forward?
So, Dr. P, for a layperson like me, I know I've been very interested in hearing about your work with that trial consulting side. So, essentially, can you boil it down? Is it like emotional IQ, essentially, of kind of understanding how a juror may perceive arguments and ultimately what kind of outcome you might expect based on certain arguments?
Okay, yes, but there is an important caveat here, and that is that trial consultants do research with very small sample sizes. So to be able to say that if an individual is high in emotional intelligence or is of this particular demographic would be favorable to his or her side is not intended. What the intention is to bring forward what you have seen during mock trial and focus group and present to attorneys in common language whether you see, and I'll say attribution, to be able to say to an attorney, it appears as though the jurors are attributing fault to the plaintiff. And in this case, we believe it is a function of attribution. But these small samples really don't lend themselves very well to big generalizations. When individuals publish jury research, they're generally using large samples because a mock jury of 10 to 12 will actually give you only a sample size of 1. So we're not necessarily inclined to have these broad-based generalizations, just dealing with specific issues. What can you find that may be a feature that will draw an individual to a plaintiff in this particular case or to a defendant in this particular case? And I hope I'm answering the question.
Yeah, that's good. And I see there's one more question here, and I'll watch the time here. But there's a question here: can psychology be used in voir dire, or is it largely to weed out conflicts of interests? I've seen shows like Bull and thought they were fantastical exaggerations of psychology.
Yes, they are. Yes, they absolutely are. But yes, we do use our knowledge and our resources to assist attorneys during jury selection. It is done. It is done. We, of course, can create a construct that we believe would capture jurors' attitudes during jury selection. But always remember that whatever questions you have, for example, we may think as psychologists, need for cognition is important, or belief in just world will be important if it's a particular case that involves a sensitive item. But when you're thinking about where do those questions actually go, remember that they go to the judge. And remember that the judge has the last word on whether you are going to be given the right to ask the questions that you would like to ask during jury selection. And it differs in a federal arena versus a state arena. And if you're reading legal psychology and you're taking undergrad legal psychology class, Dr. Berman will agree with me, it's in every textbook that depending on the type of case that goes forward, judges will allow attorneys in state court much more latitude during jury selection than they will in federal court. And as a consultant being present in both state and federal, I can attest to the fact that that's absolutely true. So yes, we do assist attorneys during jury selection, and we base our knowledge on what we know about the research. And so, for example, I can draw from the Timothy McVeigh trial just for a minute. When Timothy McVeigh was during the jury selection for the Timothy McVeigh trial, we knew that pretrial publicity was going to be significant in the individuals who were called to complete the supplemental juror questionnaire. And so based on the responses to the supplemental juror questionnaire, and that was exposure to the pretrial publicity, we could draw from the research and we could ask the court for a continuance. We could ask the court for a change of venue. So that's another way that attorneys work with psychologists to assist in the first stages of trial.
Well, there's one other follow-up question there. Are judges very resistant to having psychologists in the courtroom or involved in that process?
Oh, that depends. I couldn't answer that one way or the other. It depends. Dr. Berman and I told my class last week, I don't know if it was the undergrads or the grads. I'll never forget Dr. Cutler telling us a story about the first time he had to explain a factorial to a judge when he testified as a witness. So it's a different body of knowledge, the law and psychology. So to say yes or no wouldn't give that the credit that it's due. It depends. It depends on the issue. It depends on the type of testimony that is being requested, and the type of testimony will differ from those that a legal psychologist gives versus those that a clinical psychologist gives. So I can say in matters that I have been aware of and prepared for, for testimony, it's mostly statistical from my position. So, and it's been mostly pretrial. And so it's presented to the court in a different way.
And we had another question actually pop up here. Judy, in your opinion, do you think that the latest psychological research and assessment translates well into legal judgment?
I don't know what that means. You need to explain that. I'm not sure what that means.
Yeah, maybe we get some more clarity. So yeah, if you don't mind clarifying your question a little bit, I'll throw one question to you, Dr. P, that I think relates well as far as the trial consulting. And I talk to students a lot about what their perceptions are of the education that's required of them to do certain things. And my understanding from talking with you and Dr. Berman is that, at least from a trial consulting standpoint, it may not be necessary to get a doctorate, even though most students in psychology seem to focus on the long term, whether it be assessments and research needing a doctorate, but that my understanding is trial consulting, you may be able to do well with a master's. Is that true?
I don't know. Dr. Berman can take this. My experience would say no. My experience in that field would point more towards PhDs in largely the experimental arena, social and or cognitive or applied psychology will get you much further as a trial consultant. And when I say much further, it opens the door for you to have your own firm. I'm not aware of any requirements for hanging a shingle as a litigation consultant, so to speak. I do know that some firms, I don't know how many it would actually amount to, will hire research associates and research assistants with master's level training. I'm not sure what that master's level training actually is. Most of my experience is at the PhD level in experimental psychology, in social, clinical, applied areas. Those individuals have the most to offer in terms of what psychology can assist attorneys with as a consultant. Remember, you're not hired for what you know about the law. You're hired for what you know about psychology.
I think we got some clarity on that one question there too. Does forensic psychology research get sufficient consideration in judgment? Does that clarify that at all?
Maybe the forensic psychologist might be able to answer that a little bit better. I know there's going to be a webinar on forensic psychology coming up soon, right?
Yeah, there are several, yeah.
I'm not sure how to respond to that.
And maybe on the legal side, and this may be a gross kind of overcharacterization, but my understanding is that legal psychology tends to be more procedural and more thinking macro level, which I think speaks to kind of the applied nature of your work versus more clinical. So from in terms of maybe influencing judgments, then do you feel like your work as a trial consultant or as a legal psychologist in terms of the statistics that you're providing, does that help influence any sort of outcome or procedural work?
Oh, we would need another couple of hours to talk about that. But oh, yes. I've had a couple of wow moments as a trial consultant where our work in particular cases made it to trial in those particular cases and affected judgment. So again, it's esoteric, it's particular to the case. Macro, yes, certainly if you are filing a motion with a court to change a venue or to continue a case, you need that body of literature, as we did with Timothy McVeigh. And I believe that Professor Penrod wrote the change of venue for us in that particular case. You rely on the literature. So that's the macro to change particular cases in the applied arena. But as a consultant, yes, I've seen our individual casework have an impact on how cases move forward. It's very exciting. It's a field for young people. Don't be old and get into consulting, because there is a travel, there are very long days, but it's very exciting. It's an exciting area.
Great. Well, Dr. P, thank you so much. This was really helpful. We're going to let you sign off, and we'll pass it over to Dr. Berman. And as Dr. P mentioned, if you have any questions, feel free to email with her directly, and we'll share her information out as well.
Thanks, everybody.
All right. I'm going to do a brief intro of Dr. Berman here, make sure we give him his fair. I'm going to make you a host so you can put your slides on. And in the meantime, I'll give you a brief introduction for Dr. Berman. As I mentioned, he received his PhD at FIU as well. He's currently a professor of psychology here at Roger Williams, and he studied human memory for 28 years and authored many peer-reviewed articles and book chapters related to eyewitness memory, police lineups, jury decision-making. Dr. Berman teaches both undergrad and graduate here in cognitive psychology and psych and law. He's also served as an eyewitness expert in more than 75 cases, both at the state and federal level, and also delivered workshops to the Rhode Island Municipal Police Academy, delivered papers to the Rhode Island Bar Association, and served as an eyewitness expert for the Rhode Island Task Force charged with by the state legislature to develop police procedures to improve eyewitness identification. What he also hasn't included here, but he received a national award this year, and I'm going to get, I think, was it APLS for Advisor of the Year? He can probably clarify me there, but we were really excited for that acknowledgement of his work. He's very well loved here, certainly a really interesting guy, as you'll hear in a moment. So Dr. Berman, take it away. Thank you so much. And for anybody who has questions, feel free to enter them and we'll post them shortly.
Thank you, Marcus. Good evening, everyone. I understand we have potential future students and alumni and colleagues here, so welcome. I'm working a little bit of a disadvantage tonight. One, at 5:30, I don't know about you, but my processor slows down a little bit. And of course, I'm trying to push the largest area of psychology and all the literature that's accumulated over the past 45 years in legal psychology, particularly in eyewitness, which is the largest area of legal psychology, the largest research area, into 20 minutes. So what I tried to do here was introduce you to eyewitness memory in general, some of the problems we face in the area of eyewitness memory and mistaken identification. So brief background. And then one of my research programs as it relates to eyewitness identification. If there's time, I can discuss other research programs that I have running because when you mentor or supervise a number of different students, they all necessarily can't jump into one research program. So I have a number of different programs running, but this will be one of them. So let's get started with the background of eyewitness identification. So what we've been working on in relation to eyewitness memory recently in my lab is to take data from the Innocence Project. So the Innocence Project is a nonprofit organization that tests incarcerated people who have claims of innocence. So they'll test their DNA if they can find the DNA, number one. So if you can track down the DNA and gather that evidence, then the Innocence Project will test the DNA from the crime scene against the DNA for the person who is claiming innocence. So they assist, they assist in exonerating the wrongfully convicted using this scientific analysis. They are also responsible for reforming the system. So in addition to the testing and and helping exonerate innocent people, they're also responsible for developing legislation and writing bills that help reform the system that's responsible for this unjust imprisonment. So, and I have these facts on other slides, so I'll go over very briefly what they are. I'll wait on this slide because it's on the next one. But the primary goals of the IP, which is the Innocence Project, are to exonerate, like I said, only through DNA evidence, to improve the system, to reform the system, to support those who have been incarcerated falsely, such as through compensation, through workshops, through training, once they are exonerated, and to educate. So you may be educating judges, attorneys, you may be educating legislatures, state legislatures, who are who you're speaking on behalf of a bill in front of. So trying to educate them about some of the problems inherent in the criminal justice system, and passing a specific bill that will help either for compensating those who have been erroneously convicted, or developing eyewitness reform. So if passed, the police department would have to follow certain procedures that are based upon the research and what the research shows to reduce bias when performing lineup procedures. And it started 28 years ago, the Innocence Project, in Cardozo Law School in New York, in a small little room. And there are currently 68 Innocence Network organizations. So from 1 to 68. Here in New England, we have one New England Innocence Project, and that's located in Boston. So now I can click to the next slide. So to date, how many people have been exonerated just by the Innocence Project? Of course, there's been other exonerations from other projects and other innocence networks, but let's just focus on the Innocence Project. My research program that I'm going to talk about deals specifically with these Innocence Project exonerations. So to date, there's been 375. Here's some of the faces of those. A slide many of us use to kind of show the real faces of the people who have been exonerated. When you look at what's nice, maybe the only nice thing about this is that you're able to gather information about who these people are, demographics. You're able to gather information about the cause of their erroneous conviction. Was it due to, and I'll speak a bit very quickly about some of the causes of being falsely incarcerated. But the leading cause is mistaken identification. But other causes include false confessions. They include incentivized witnesses, government misconduct, which includes prosecutorial misconduct that Dr. Platania previously spoke about. But on average, they've served, when you look at the time spent of these 375 exonerees, they serve an average of 14 years incarcerated. And when you add up all their years together, it averages or amounts to 5,284 years combined. So some quick facts. The first exoneration using DNA was in 1989. 37 of the 50 states have one exoneration cases. And the average age for the exoneree at the time of conviction was about 26 years old. And the average age of exoneration was 43 years old. So many of the years spent for these falsely convicted individuals is in their 20s and 30s. Of course, some people have spent significantly more time than 14 years in prison. In some cases, over 40 years falsely incarcerated. See here that out of the 375 on this bullet point right here, 21 or 6% of them, 6% of the exonerees served time on death row. 32% of the cases involved multiple misidentifications of the same person. So let's break that down. 69%, the leading cause of erroneous conviction is due to mistaken identification. 69% of the 375 were due to mistaken ID. 32% of those mistaken identification cases involved multiple witnesses. What that means is multiple witnesses came forward and testified against the defendant who was innocent, but who mistakenly pointed him out as the perpetrator of the crime. Most of these crimes, by the way, are crimes involving murder or sexual assaults. Other causes of erroneous identification that I do not study, I study a little bit of false confessions, but the second leading cause is misapplication of forensic science. So before DNA, the criminal justice system at trial, the state or the government may have used forensic science such as bite marks on the victim's body to try and prove and successfully prove, if they were able to get a jury to convict the defendant, to prove that this is the person who committed the crime, or fingerprint analysis. All science now that is debunked, or in some cases considered to be junk science. But of course, at trial, jurors were often told that this science, such as fingerprints, was highly accurate. I've heard experts in some cases testify that it was 99% accurate with little room for error. We now know that those statements were clearly overstated, or those claims were overstated. And it's the second leading cause of erroneous conviction when you look back at the files of the 375 exonerees, and you look at their main cause of what they were convicted. Junk science is second. The third is false confessions, the third leading cause of erroneous conviction. So these are innocent suspects who confess to a crime they didn't commit. And I know you're wondering who would do that. Well, when you look at the process of interrogations and the time spent, it's pretty easy to see how somebody might confess falsely. Take a 16-year-old who is told that if you tell us what we want to hear, you'll be able to leave and go home. Time spent on average in these kinds of confessions may be up to 14, 16 hours, being confronted with false evidence ploys. We have your DNA. We have a camera that showed you leaving the building. We know it's you. And of course, they don't have any of this evidence, but it's legal to provide false evidence to suspects. Supreme Court has ruled that it is fair and legal to do that. So when confronted with false evidence, Some people actually come to believe they committed the crime, or some people are complying to police and feel coerced in order to confess. Other ones in other exonerations or causes of erroneous conviction, excuse me, involve informants. So these are people who may be incentivized. That is, hey, if you go in the cell, come back with something and we'll do something for you in return. So somebody's planted in the cell with the defendant and then comes back and says, he told me he committed the murder. And then 264 out of the 375 have received some type of compensation after their release, but that depends on the state. 38 states currently have compensation bills on the books. It goes state to state. Rhode Island does not have a compensation bill. We keep going back to the well and the legislation and the legislators and ask for a bill, but it's been denied for many years. So we know that out of 365 exonerations to date, 165 of the real perpetrators have been identified. The rest are still outstanding. And we know that the causes are due to flaws in the criminal justice system, procedures that could be improved, identifying somebody who you think committed a crime, who's innocent, who then you bring in to interrogate. And then after 12 hours, get a false confession from them. Eyewitnesses misidentified innocent people in 260 or 71% of those convictions. So it ranges from 69 to 71%. Here's some numbers for the flawed science, such as the fingerprints. It helped convict 161 people. Here's the number for the total false confessions, or 28% of those cases. It was 102 people. And when you think about the Innocence Project and how they get notified, they get letters from people that say, hey, I didn't do this. And please help me, because the Innocence Project, again, is nonprofit. So they don't get paid. All of the money comes through for the testing, which may be over $1,000, comes through donations and fundraising. But they get about 3,000 letters a year asking for help. And testing exceeds sometimes over $1,000. So it can be quite expensive. When you look at the demographics of those exonerees, the majority of them are African American, about 61%, Caucasian making up 30 to 32%, and Latino consisting of 27 people, or 8%. So how does my research fit into the Innocence Project? At least one part of my research. Here's what we did. We took all of the Innocence Project cases. So we took data from the actual erroneous conviction cases. So research primarily focuses on, let's say, lineups. You're doing lineup research because you are aware that lineups are problematic, or you want to test the current procedures that they use, that law enforcement uses for lineups. So you look at their current instruction and you test their instructions in the laboratory, and you see if conviction rates are in some way biased against the defendant. If you find that, then you look to improve instructions and then test your new instructions against the current to see if it leads to or reduces bias. For example, if law enforcement gives a witness an instruction prior to viewing a photo array or a lineup that says, okay, I want you to be careful, take a good look, and when you see the person, just point them out. Now, that may seem unbiased. Take your time when you see them, but in fact, it's extremely biased in that it doesn't account for the fact that the person in the photo array may or may not be in the lineup. So what does that do? It leads to more choosing behaviors, which is interesting. Well, what's the problem if the person chooses more? The problem is the person in the photo array, the suspect, may or may not be the perpetrator. So if you have a perpetrator absent lineup, so who's in the lineup if it's not the perpetrator, the bank robber, the armed robber, right? Who's in the photo array if it's not the perpetrator? Somebody who fits the description of the perpetrator. And these descriptions are very general. Between 5 foot and 6'1", wearing a hoodie or dark clothes, medium build. That's it. So if you're in that area, Caucasian, if you're in the area and you fit that description, police are going to question you. And they have to, particularly if you're an armed robber. And the question becomes, how are they able to put in procedures that would allow a photo array or an interview or an interrogation that minimizes the amount of bias? So in the past, that's how lineups have been studied. What are the procedures and how do we improve them? What we did was we wanted to look at actual erroneous conviction cases, which have received little attention in the reform and the eyewitness literature, and look at what happens in real eyewitness erroneous conviction cases and what factors are involved in those cases. So lab and field data, the second point here, are typically used to post-diction real-world cases. So in other words, the lab studies take cases after the fact and test procedures. But what the courts have said is they lack ecological validity. That is, what you do in the laboratory doesn't really conform to what goes on in the real world. You're not pulling guns on people or weapons on people in the lab. We're not allowed to do that, even though we know it increases ecological validity. It's unethical. We don't use, if the participant in the lab chooses somebody from the photo array, they don't go to prison. So the courts say that the stakes aren't the same in terms of the decision on part of the eyewitness. So because these cases have been criticized by the court, and in some cases, I believe incorrectly, I'm not going to go into why, but we say if you use real data from real cases, it increases the ecological validity, which may ultimately end up in more acceptance by the courts for this kind of research. So what we did was, I'm going to move to the third point for the sake of time. The present study, or one of my research areas, uses this archival data set to help understand what factors were involved in real cases, such as the case characteristics, such as who's the witness, was the witness the same or a different race of the perpetrator, what were the variables involved. Gary Wells, who's one of the premier and world-renowned eyewitness researchers, separated two kinds of variables in these cases: estimator and system. Estimator variables are factors we don't have control over. Things like the time of day that the crime was committed. Police officers or the criminal justice system doesn't have control over that. Whether or not a weapon was used, we don't have control over, or the criminal justice system doesn't have control over the presence of a weapon at the time of the crime. The race of the perpetrator, the race of the victim, how long it lasted. These are all estimated variables. System variables are factors the criminal justice system has control over: who you put in the photo array, how many people, whether or not they match the description or the physical characteristics of the suspect. The lineup instructions I discussed earlier, that he may or may not be in the lineup, that's under the control of the criminal justice system, right? You can give any instructions you want. What you say to the witness following the identification, if everybody says, great job, you got him, that's who we thought it was, or they clap for the witness, what effect does that have? Well, in the laboratory, when we test this, it inflates confidence of the eyewitness. They now are even more confident that they believe it's the right person, and it also affects other judgments at the time of encoding. That is, if you're given this feedback, you got them, good job, you believe that, or you report having a better look, or believing that you looked longer at the suspect, had a better opportunity to view the perpetrator. So these are some of the factors that we want to parse out of these real world cases. And then finally, looking at what legal safeguards were used in these innocent project cases. Criminal justice system has said we have safeguards to protect the innocent, such as the attorney being present at the lineup, the judge suppressing a biased lineup. Well, how often were these safeguards used in these actual cases? So that's what we did. And here's a brief method of what we did. What time? Oh boy. You see, this is my biggest challenge, right? So I'll go through this very quickly. We just coded all those Innocence Project cases that were related to eyewitness memory. So they were only eyewitness variables, and we coded them for case characteristics, those estimated variables I discussed, those system variables like lineup instructions, estimated variables, like I said, are things like the presence of a weapon or time of day, and the presence of legal safeguards. And what we found was, which is kind of interesting, is that out of those Innocence Project cases, only 104 involved just a sole eyewitness, right? Where eyewitness was the only factor relevant to the conviction. It didn't involve other things like incentivized witnesses or government misconduct. Then when we wanted to find documents such as transcripts and other factors to get information about our categories, we found that only 57 cases had attached documents. And this was from the Innocence Record, which is another organization that deals with exonerees. The Innocence Project doesn't have any attached court documents associated with the particular case. And, just a brief frequency of our data, you can see here, we talked about safeguards, right? So criminal justice system says, hey, the attorney could be present. That will reduce bias, or he or she will be able to pick out bias. And look, when we did an analysis of the cases based upon the transcripts, only 3% of those cases had an attorney present. Only 9 of the cases, or 15%, used an eyewitness expert or called an eyewitness expert. So we're really able to get a good feel of how these safeguards are being used in terms of the system variables, such as lineup instructions or the way you present the lineup, whether or not they were recorded to later view to see if there was bias. Recording, only 5 of these lineups were recorded. For lineup instructions, for first ID, we were able to code for how many received appropriate instructions or non-biased versus biased instructions. Okay, who do you think did it? Or take your time. Tell us when you see the person. You can see that 23% of these cases involved biased lineup instructions. Only 28 or 52 that we were able to see through transcripts had unbiased instructions, and a quarter of them didn't even report what kind of instructions were used. So what does that do? Well, the findings tell us a number of things. One, there's a lot of missing data in these cases. We want to put together and try and put together a system where every case has attached documents associated with it. So it could be analyzed by organizations like the Innocence Project or researchers who want to look at factors that are relevant to test in the laboratory at a later date. So the first thing is, there's a lot of data missing. How can we find a way to organize this data in an appropriate way and in a standardized way? You can see the third point. A standardized way said if you're looking for information, it's in the same place for every case. And then also take this data, this is the last point, and then I'm gonna finish. But how do you take this data from real world cases and use it to inform new experimental paradigms, which are my other research programs, right? How do you take the current data and use it to inform new experiments that will allow you to move from post-diction, that is explaining it after the fact, to prediction, that is using the data to inform and predict behavior based upon hypotheses that comes out of these erroneous conviction cases. So I apologize for going over time, but it's really the largest, well, it is the largest area in legal psychology in terms of research. And for the record, when I speak in front of legislatures to try and pass eyewitness reform, which we tried in Rhode Island many years, none of which were passed at the legislative level, I get 5 minutes. I have to take all of this and reduce it to 5 minutes, which I don't think I do successfully if not getting the bill passed is any indice of whether or not it was successful. So thank you for your time, and I'm happy to answer any questions.
Dr. Berman, that was great. Thank you. So I guess there's actually a good question, I think, that dovetails well with what you were just describing. Why, in fact, and you were talking about the Supreme Court ruling on this earlier, why is it legal to provide false evidence to suspects? And, why do police pressure false statements if their pursuit is safety and justice?
Well, the Supreme Court, weighed the prejudicial and probative value of this kind of information, false evidence ploys or presenting false evidence to suspects. And they said that they believe, particularly with violent criminals that we all can agree with, we want off of the streets. They thought that it had more probative than prejudicial value. But what we find is that false evidence ploys are one of many factors that contribute to false confessions. It's not the only one, or it's not the most significant one. There's many factors, like the type of interrogation methods that they use, or that somebody is vulnerable based upon their IQ, or sleep deprivation. So that it's legal. If it's legal, we now need to decide, well, does it contribute to false confessions? And then if it does, if we find that in the laboratory, it's our job to try and reform the system and make recommendations on how to reduce it.
Everything you've been discussing, Dr. Berman, reminds me of the case of the Central Park Five, and I'm sure there's plenty of other great, obvious evidence of all of this happening. But there were some questions about the legal repercussions for folks that work in the system. I think about the DA and the Central Park Five, and kind of at least the public kind of falling from grace that she had. But can you speak to that? And I think even broadly, when you think about Central Park Five or others, and even just looking at the Innocence Project, overwhelmingly, this seems to have a pretty large influence on people of color. And you look at whether it be African-American or Latinos, you're talking about 7 out of 10 of the folks that you looked at are non-white. What do you see in the field of legal psychology and maybe the research that you're doing that can help make some inroads to fixing some of those issues that are so rampant?
Well, the first thing you have to understand is that it's a slow process. right? Psychology as a discipline, what it dates to 1879. So we're pretty new. And then, of course, legal psychology, although some of the first work was done in 1908, and it wasn't accepted well by the legal system. The work by Hugo Munsterberg, and he published a book on the witness stand. And when he said, hey, psychology can help the legal system in understanding eyewitness memory and some of the problems that may occur with memory, it wasn't well received. And you know, eyewitness research didn't occur again to the 70s. So we're only about 40 to 45 years old in terms of this research area. So making inroads into a legal system that's hundreds of years old, of course, in America, but it's much older in England, from which our system came from. You have to be patient. And what you have to do is you have to try and figure out and accumulate enough convergent data to make, because you don't want to give recommendations to a criminal justice system based upon a couple of studies. It takes years and in sometimes decades of studies to try and figure out what's going on and the best way to reform, let's say, a lineup instruction. And then from there, you know, how do you get it out there? So in the beginning, we publish this study, but who reads it? Well, we do. The people who know the research and who enjoy reading about it, and we talk to each other at conferences. But you have to get out there more, and it's starting to get out there more with social media, with films, and like the Central Park Five and other the recent Netflix, what was it called? Mind of a Murderer. Right, the Avery case, which was an Innocence Project case initially. Some of you may know that. I don't think I have the title right, but it was a Netflix documentary that's been very popular. So what you have to do is be patient and kind of get the word out there. Speak with attorneys at the Bar Association, speak with judges, speak with law enforcement, give workshops, and you hope to think over time you have grassroots and it grows, and it's starting to. So in Rhode Island, although it's not legislated on how to do lineups, a number of different cities like Barrington, like Warwick, like Providence, use the recommended procedures from the eyewitness literature. So it doesn't have to be legislated to force police to do it. If police buy in, then I think it's even better because they believe in the procedure, but it takes time for this buy-in to occur. And that buy-in only occurs after the research has sufficiently been put together, which in some cases is decades.
Yeah. All right. Well, Dr. Berman, this has been great. And I want to thank you for your time and all this great information. Thank you to everybody who's joined us tonight. Sorry we went a little behind, but I know a lot of you are still there and hopefully got a lot of great value out of this. If you like this session and you're interested in learning more about forensic psychology, we actually have 2 more sessions coming up. You probably saw in your email, but you can visit grad.rwu.edu/events. And you can see our 2 remaining lectures. One is Wednesday on life without parole sentences for juveniles. And a week from Wednesday, we'll be having a session on masculinity and sexual violence. And those are both going to be at 5 p.m. Eastern time. So I hope you'll have a chance to join us. We'll reach out to you as well, see what you thought about this session. We hope it was helpful for you in kind of thinking about your next steps in pursuing a career in either of these areas. But certainly reach out to any one of us if we can help you at all. But thank you again for your time. Please be well, and we hope to see you at a future lecture.
Yes, thank you, Marcus, for the opportunity. And if anyone, once again, touch with me, or if you have questions, my email is gberman@rwu.edu. If you forget it, just look on the website. And please send me an email about any questions regarding the program or the legal psychology research going on in the program.
Great. Thanks so much, everyone. Have a great evening.
Thank you, Marcus.